book. Appeal in the matter of FS Commercial Ltd and His Majesty's Commissioners for Revenue and Customs.
Yes, Mr. Brown.
May it please your lordships, I represent the taxpayer, the appellant FS Commercial Ltd, with Mr. Morse sat behind me,
Yes.
and learned friend Mr. Watkinson appears for the Commissioners of
Yes.
His Majesty's Revenue.
Well, I can tell you that we've read the decisions of the FTT and the UT, and we have read the 4 skeleton documents.
I'm grateful, my lord, thank you. This case is an important one and has a much wider significance, as I'm sure you will have, your lordship will have ascertained, potentially for all taxpayers registered for VAT, where there is a question of an input tax claim in respect of this court's interpretation of the legislation and authorities. What I would like to do first, with your leave, my lord, is to very, very briefly go through the facts. They appear in both skeleton arguments. In respect of the appellant's skeleton, they are at page 18 of the core bundle.
Yes.
You will see the first interaction, if you like, between the Commissioners and the appellant, paragraph 4.
Yeah.
Officer Mills email 2nd of October asking for information, including any purchase invoices with £1,000 of input tax. The appellant responded 6 days later. Please find attached bank statements together with all invoices with input VAT exceeding £1,000.
Yeah.
And this is in respect of the 818 VAT return, of course. That's what it was limited to at the time.
Sorry, limited to what?
The VAT return for the period 818.
Right. Yeah.
Officer Mills responds on the 10th of October. Looking at these, I think the majority of input tax derives from Verity Limited. I've been unable to locate the invoices that relate to these amounts. Can you let me have the corresponding Verity invoices? Then we have the 11th of October. The appellant replies, and if I could invite your lordships to go to the supplementary bundle, page 70.
Yes.
In the middle of that page, you will see an email from Dave Clark, 11th of October 2018 at 11:12 hours to Officer Mills. Hi, Steve. Sorry for the confusion. FS Commercial operates an outsourced supply chain. There are no invoices from Verity Limited. Verity is just a code we use. Entries referring to Verity relate to a consolidated amount of invoices VAT charged by our suppliers. So these amounts could consist of anywhere between 800 and 1,000 invoices. Now bear in mind that is just for this single VAT return. Unfortunately, I am out of the office now on annual leave business until the 22nd of October, when I will be able to supply you any info you require, should that be a spreadsheet with all invoices or a sample of paper invoices if preferred. Now I draw your attention to this, your lordships, because you'll have perhaps gleaned from the decision in the Upper Tribunal, the Commissioners were alleging there was some sort of trying to play fast and loose with the VAT system. And all I'm trying to do, my lords, is to show that the appellant was engaging with the Commissioners at the time. The next communication between the parties paragraph 8 of my skeleton, page 19, you'll see that on the 17th of January.
Just before you go there, sorry,
Yes.
I'm just looking as you're doing this at the FTT's decision,
Yes.
and there was actually another email on the 18th of October.
Yeah.
So before that one of the 7th of January. So this is page 124.
Of which bundle?
Sorry, of the core bundle.
The core bundle, thank you. Bear with me a second. Yes. So you're correct. Thank you, my lord. 18th of October, Officer Mills emailed the appellant. In terms of Verity Limited, I need to see evidence of the companies and invoices that make up the supply. Please can you provide those invoices in a spreadsheet listing? Then we have Officer Mills writing 7th of January asking for requested business records since the commencement of business in 2010.
And by the 7th of January, I would infer that Mr. Clark was back in the office because he said he was away until the 22nd of October.
Yes.
So between October and January, nothing was produced in response to Officer Mills' request.
I would say, I don't wish to give evidence because I got into trouble that before with the Upper Tribunal, which I wasn't, but I would say that that was, yes, that must be accurate. So yes, my lord, 7th of January 2019, the officer requests business records since commencement in 2010, which by that time, of course, would be approximately 9 years, amounting to some 30 odd VAT returns, with one assumes 1,000 invoices, up to 1,000 invoices per period. We then have the response on the 21st of January, where Aspire Limited, who are now were then instructed by the appellant to deal with the matter, sent documents relating to the 0818, the August VAT return. And then thereafter, of course, there is the communication 25th of January from Officer Mills, and then less than 2 weeks later is the assessment. So that's the context. The appellant asked for a review of the decision by an independent VAT officer. That review is at page 89, the supplementary bundle. See that addressed to Mr. Clark, FS Commercial Limited, review conclusion letter. I can invite your lordships to tab down to page 92, or turn to page 92. You'll see at the top of the page, input tax. The officer sets out sections 24 to 26 of the VAT Act 1994 and Regulation 29.1, which we are dealing with today. Then Regulation 29.2 allows for a claim to be made for input tax despite not having an invoice if other evidence, as allowed by the commissioners, is held to show VAT was charged. It is considered that the company does not hold a VAT invoice that is required to be provided as per Regulation 13, and that the information provided does not amount to sufficient evidence. So there are two decisions there. The first is the commissioners say they consider the appellant does not hold a VAT invoice, and then exercising its discretion.
Which decision is subject to an appeal to the FTT? Is it the officer's decision, or is it the review decision, or what?
Well, it has to be, my lord, the review decision, because a review officer may uphold a decision on a completely different basis to the original officer's decision.
Conversely, if the review decision is different to the first decision, then it would be that you'd either be accepting or rejecting.
Yes. I mean, the commissioners have a discretion, once an appeal is underway, to effectively, my learned friend will correct me if I'm wrong, to change their minds, if you wish, because the appeal is against the assessment. And therefore, following Bupa purchasing, the commissioners do have a discretion, almost in the same way that an appellant could.
Just in simple terms, so that I can understand it.
Yes.
You get assessed by an officer in the normal way.
Yes.
You have some problem with that, so you ask for a review.
Yes.
The reviewer then makes a decision.
Yes.
And that review decision is the commissioner's decision.
Yes.
Is that how it works?
Yes, I mean, of course, you don't have to have a review in the first place.
No, I understand.
But nevertheless,
where you have a review,
yes,
which may produce a different figure,
yes,
and as you say, may produce different reasons,
yes,
that becomes the taxpayer's
that
obligation or target for an appeal to the FTT.
Correct, because it is thereafter that you make the appeal.
Right, so your submission is that whatever happened with Mr. Mills, that we need to focus closely on the review decision.
Yes.
In order to see what it was that the commissioners ultimately decided.
Correct. Yes.
Thank you.
I only mentioned the facts to put it into context. That was all. Now, in terms of the law itself, my lords, I'm acutely aware, my Lord Justice Lewison, of course, and Tower Bridge, I'm assuming you don't wish me to take you through the legislation per se, other than perhaps Regulation 20.
Well, I think you must take your own course, but can I, before we leave the review decision, look at what the review decision said was disputed, which we get on the bottom of page 89, top of page 90. Decision has been issued that the input tax cannot be recovered as sufficient evidence has not been presented. Your representatives have stated that sufficient alternative evidence has been presented. So there's no assertion there that actually we've got compliant invoices. What is being said to the reviewing officer is you've had sufficient alternative evidence.
That's what was put forward at the time, my lord. Yes, I don't disagree with that.
Yeah.
That's what was put forward at the time. But nevertheless, the decision comes back. The commissioners consider you didn't uphold sufficient those valid vet invoices, and therefore thereafter you exercised that discretion. So, my lords, back to the law. I don't really think I need to take you through it in any detail whatsoever. Suffice to say that there is a three-stage approach or process in respect of claims for input tax. The first stage is the eligibility, the right to deductible tax. The second is the exercise of that right. And the third is the verification of and or collection of VAT by HMRC. respect of Regulation 29, VAT regulations, that appears at page 36 of the authority handbook. Paragraph 29, 1. Save as the Commissioners may otherwise allow or direct either generally or specifically a person claiming deduction of input VAT under Section 25 of the VAT Act shall do so on a return made by him for the prescribed accounting period in which the VAT became chargeable. Save that, and I will mention this now and perhaps refer to it later, where he does not at that time hold the document or invoice required by paragraph 2 below, which is the requirement for a valid VAT invoice, he shall make his claim on the return for the first prescribed accounting period in which he holds that document or invoice.
And that presumably is to accommodate the decision in terror.
Yes, and my Lord, I'll perhaps go through it later in respect of the final paragraph of the Upper Tribunal's decision, where almost as an aside, the Upper Tribunal said, well, issues regarding that sort of whether an invoice is or not a valid invoice is supervisory, and my submission, that's clearly wrong. If one is arguing that one holds valid VAT invoices, as this is what this case is all about, but if the Commissioners, for example, see an invoice that has been presented to them, and the Commissioners say, no, that's not a valid VAT invoice, that is an appellate matter for the Tribunal. And the First-tier Tribunals always treated such challenges as appellate. Then, if you are in the First-tier Tribunal, the Tribunal says, no, we don't think it is a valid VAT invoice. Then one moves on to the supervisory jurisdiction as to whether the Commissioners were reasonable in denying the input tax or refusing to exercise their discretion to allow it, more accurately. Moving on to...
Sorry, just before leaving 29.1.
Yes.
In what way would the proviso at the end of 29.1
Yes.
apply in a case where somebody did in fact have an invoice but was not producing it?
Well, that proviso doesn't apply at all because the person has the valid VAT invoice. What it's allowing for is somebody who doesn't have one.
Yes, so it doesn't apply.
It doesn't apply at all. No. It applies, for example, if I make a claim for input tax, my lord, I don't have a valid VAT invoice, but subsequently it arrives 12 months later.
Right. So it's not this case.
It's not relevant to this case at all.
No.
No.
Thank you.
We perhaps, my lords, get to the crux of the matter. 29.2. At the time of claiming deduction of input tax in accordance with paragraph 1 above, i.e. the taxpayer has submitted a VAT return, the person shall, if the claim is in respect of, in this case, A, supply from another taxable person, hold the document which is required to be provided under Regulation 13, i.e. in layman's terms, a valid VAT invoice. And then moving down over the page for the tail piece, page 37, provided that where the Commissioners so direct either generally or in relation to particular cases or classes of cases, a claimant shall hold or provide such other evidence of the charge to VAT as the Commissioners may direct. Now, in all the authorities, including Tower Bridge, it's been a fact of the case that something has been provided to the commissioners, and the commissioners have decided that they are not valid VAT invoices.
I'm very sorry to slow you down.
Oh, my lord, no, please.
Because I'm not familiar with this. Could we just look at 29.2 now and see how it fits
Of course.
together? It provides that at the time of claiming a deduction under paragraph 1,
Yes.
a person shall, if the claim is in respect of 6 types of thing,
In respect of what, my lord?
6 A to F, 6 things.
Yes, one of 6
Right.
things.
Shall, if the claim relates to 6 types of thing,
Yes.
how does the grammar work at the end of it? I mean, it says 6 types of things, and then it goes on.
There should. So the way that it works and has been interpreted is that provided a taxable person, in this case under subheading A, holds the document because it's been supplied by goods or services from another VAT registered trader, and it holds what it says is a valid VAT invoice. So that's A.
Right, I see. Sorry, the verb is in each of the A to Fs.
Yes.
Now I've okay. So, if you're claiming in respect of a supply from another taxable person, your
Yes.
obligation is to hold the document.
Correct.
Your obligation is to hold the document, except by the proviso at the end,
Yes.
that where the taxman directs otherwise,
Yes.
you're to hold whatever the taxman directs you to hold.
Well,
Is that it?
but it refers to such other evidence.
Yes. Well,
Tailpiece.
what?
So if you hold a valid VAT invoice, it doesn't matter what the commissioners may ask you.
I see. So your case is that we can stop at 2A,
Yes.
and the proviso's got nothing to do with it because, as a matter of fact, I do hold a document.
Well, no, I don't see you should disregard it because part of the case is, as interpreted by the European courts and everybody else, the tailpiece where the commissioners may direct other evidence, that is the discretionary point. The commissioners may, in the absence of a valid VAT invoice, accept other evidence.
But do you say that the commissioners did have a discretion on the facts of this case, or that they didn't, because you say that the taxable person did hold a compliant invoice?
Well, I say either they don't have a discretion, but perhaps put it more subtly, if they do, their exercise of a discretion effectively only kicks in, if you like, where there is no valid VAT invoice held.
So if the taxable person does hold a valid invoice, which I understand is your case,
Yes.
the proviso does not, to use your phrase, kick in. And that would mean that there is no discretion in HMRC. Is that right?
What I say, as a matter of how the law is read and has been interpreted, it is and has been on the case that no valid VAT invoice has been held.
Well,
discretion
those are the
kick.
facts of particular cases,
Yes.
but we are looking at what this regulation means.
Indeed.
And I want to understand whether it is your case that, on the assumption that your client did have but did not produce
Yeah.
valid VAT invoices,
Yeah.
HMRC had no discretion because the proviso did not apply, or whether because your client did not produce the invoices it was required to hold,
Yes.
despite the commissioners having requested
Yeah.
their production, there was a discretion.
I think, in a way, it's almost an alternative argument. Yes, that what the law says is the discretion kicks in if you do not hold the valid VAT invoice. If you do, but don't produce it, if the discretion is, let's say for want of a better word, considered by the commissioners, that must mean the commissioners have decided that the appellant did not hold a valid VAT invoice, as per the review officer's letter. So the review officer was correct in his approach to the problem.
How does this tie in with paragraph 4 of Schedule 11 to the
Yes. If I
VAT Act? Because that, which is at page 23, because
Yeah.
there the commissioners may, as a condition of allowing input tax,
yes.
require the production of such evidence relating to VAT as they
Yes.
may specify.
With respect, Marlon, can I just hold you there, because there's just one more point I wish to make on the last bit, if you're happy with that.
Yeah.
One. Thank you. Because what I was trying to go on to say, my lords, is if there is a case where a taxpayer submits their VAT return on day 1, the commissioners on day 2, we want to see the valid VAT invoice, and then on day 3 issue an assessment because they've not seen it. As purely as an extreme argument, is the appellant's only recourse then a supervisory jurisdiction of the tribunal to say that the exercise of the discretion was unreasonable on the information it had before it? It has to be the case that the taxpayer must be allowed to argue, no, I held a valid VAT invoice, and that is an appellate matter. Whether what's contained in the invoice amounts to a valid VAT invoice under Regulation 13.
Just before we leave the proviso to 2,
Yes.
would the proviso, in a particular case, not this case, allow the commissioners to require, in a sense, it could be used to alleviate the taxpayer's problem in certain circumstances, namely you've got a problem with the invoice, but we are willing to consider
Yes.
other
Well,
material. That it could be an alleviating proviso.
Oh, it certainly is.
But it could, that may be what's in the mind.
Yes.
Is there anything about it that suggests that it couldn't be a toughening up proviso? In other words, but because you're a notorious person and we've had problems with you for ages,
Yes.
We're going to require something more.
I mean, there is that, of course, because as you, and it doesn't concern your lordships,
No.
there is an alternative assessment in this case where the commissioners say we actually don't.
But at the moment, I'm
first.
only just looking at the wording of
Yeah.
this section and trying to see how the proviso fits with the 6 cases.
Yes.
That you say, as I understand it, that the proviso can be brought into play either for or against the taxpayer, and regardless of whether they hold or don't hold the document.
Regardless of whether they do or don't hold the document. Yes, I would say that well,
So-
the power to require further information, which was my lord's point,
Is going to
under Schedule 11 of the VAT Act, the commissioners do have that power, but there is no appeal against that requirement to provide additional information per se. There is no appeal against a schedule, paragraph 4, Schedule 11 requirement to provide, and so therefore that power must relate to, for example, a Regulation 29. Exercise of discretion. Because you have Regulation 29 says the commissioners can ask for, in respect of input tax, requests for information. That ties in to the Para 4 Schedule 11 in the Act itself, which says the commissioners may do that.
I'm just trying to think of this practically. Under Schedule 11, paragraph 4,
Yes.
it says that the commissioners may, as a condition
Yep.
of allowing or repaying the input tax, require the production of evidence.
Yes.
Plainly, they can say, we want to see the relevant invoices under
Yes.
that
Yes.
section.
And other information. should
And
also
but
require.
let's just stick with invoices for a minute.
Yes.
They ask the taxpayer for the invoices, and the taxpayer doesn't hand them over.
Yeah.
If you just pause there,
Yes.
so the taxpayer has not handed them over
Yes. For whatever reason.
for whatever reason. The tax authority can then say, right, well, you haven't satisfied a condition for
Yes.
allowing or repaying input tax.
Yes.
End of story.
Yes.
But the tax authority can also say, well, look, you haven't come up with the invoices, but I will allow you, if you can, to prove it by other information.
Yes.
And then the taxpayer is given the chance to do that.
Yes.
Now, is that second step Regulation 29 step, as it were?
Yes. Yes. I think it has to be. I think it has to be. At one point, something to note about Regulation 29. It doesn't say, or under any of the legislation, does it say if you have to hold a valid VAT invoice and produce it to HMRC to qualify. Nowhere in the legislation does it say that.
But if the revenue asks for it,
Yes.
then it can say, well, you haven't fulfilled the condition in Schedule 11, paragraph 4.
Yes, but that doesn't extinguish the exercise of the right to do it, because all you need of the exercise of the right to do it is to hold the invoice. This is about verification and collection.
But it comes back to the entry ticket, doesn't it?
Yes.
If you have an entry ticket
Yes.
and you show up at the theatre, then they're obliged to let you in normal circumstances, but you do have to produce the ticket.
Yes, but that's
So it's no
different.
use you going to the door and saying, "I've got a ticket."
Yes, but it is subtly different, my lord, with the greatest of respect. To be able to get in, you only need to hold it. There is no requirement for you to produce it to exercise your right to do so. And once you're inside and you're asked for the ticket, then you may well get ejected if you don't have it.
Sorry, are we here in the world of that or of the theatre?
Well, I'm sorry, I stuck with theatre. I beg your pardon.
Well, I'm not sure I follow that, because the classic moment where you need your ticket is when you're being let in.
But all you have to do is say you have the ticket, or as a matter of fact, hold the ticket.
Well, it sounded to me as if your case was, yes, I'm able to go to the ticket and to the theatre and just tell them I've got a ticket. I don't have to show it, and they're bound to let me in.
Well, what I'm saying to you, my lord, I think, is if you say, I haven't got the ticket with me, I'm sorry, they may well refuse you admission, but then it's the fight that you have afterwards, the legal fight you have afterwards. Is it an appellate matter or is it supervisory?
just sticking with the wording, although you're right that the Regulation 29(2) talks about the taxable person holding the document.
Yes.
The proviso does talk about shall hold or provide such other evidence of the charge
Yes.
to VAT. So it has to be that other evidence, may be evidence that the tax authority says actually has to be provided, not merely held.
And I don't read it as that, my lord. If you hold the invoice as required, you have the right to exercise. Sorry, you exercise the right to reclaim the input tax. It's only reading 29(2) that if you don't hold that invoice, the commissioners are prepared to accept that you hold or produce other evidence, whether that's commercial bills of lading. It would include invalid VAT invoices, for example, because just something is an invalid VAT invoice does not make it irrelevant. It's very relevant.
So what happens in a case, to take an extreme case, where the taxpayer just says, well, I've got all these invoices, but I'm not going to show them to you?
Yeah.
What?
The commissioners have the power to say we are not allowing your claim for input tax. And then it's all about the fight that you have afterwards.
But why should you have a fight afterwards?
Because they make a decision to deny you the input tax.
But you've refused completely to hand over the invoices.
And I say, but of course, the point is that you hold the invoice. Because that's the key to admission. You hold the invoice. You have an inalienable right, the right to reclaim input tax.
Well, then I go back to page 23, which says the commissioners may, as a condition of allowing or repaying input tax, require the production of such evidence relating to VAT as they may specify.
Yes, I agree with that.
And it's actually a precondition. It's not, you talk about the exercise of right. I'm not sure what that actually means.
Very well.
In this context, if you don't meet the precondition, because if you don't meet the precondition, then it seems that you can't get the input tax.
But my lord, as I said earlier, there are 3 stages to an input tax claim. Under the law, you have the right to reclaim. You have the right to reclaim it. You exercise that right when you submit a VAT return and you hold the necessary valid VAT invoice or invoices. And then everything else thereafter is about enforcement and collection and management of the tax by the commissioners. Nothing that the commissioners can do if you hold those valid VAT invoices.
Isn't that to confuse the concept of a claim with the concept of a recoupment? When you fine, you may if you've registered for VAT and if you've got an invoice and you hold it, sure, you have a right to claim.
Yes.
You have a right to claim, but they don't have an obligation to grant it.
No.
All you've established by your argument, it seems to me, is that you have a right to claim if you follow the correct procedure.
Yes, but if for whatever reason...
It's not that you've got a right to the tax.
Well,
you've got a right to claim. A claim is not is no more than a request.
No.
A claim.
I accept. And this case, my lord, is all about what happens thereafter. Is it an appellate matter for the tribunal, or is it supervisory, where the tribunal can only consider whether HMRC were reasonable or not to do so? Not appellate, which is the appellant's case, that if you do hold that valid VAT invoice, the first port of call for the tribunal is, did you actually hold a valid VAT invoice at the time? And not jump straight to supervisory jurisdiction, which is the commissioner's case, in that, well, were HMRC reasonable in the circumstances in not exercising their discretion? As I think the extreme analogy I gave earlier, day one you put your input tax claim in your VAT return. Day two, the commissioners say, can we see the valid VAT invoice? Day three, they issue the assessment, saying we've not seen the invoice, therefore, and we're not exercising our discretion to allow the input tax. Where's the remedy for the taxpayer? There. It can't be right that the only remedy is supervisory.
It might be thought, in your very extreme case, that would be highly unreasonable.
It may be, but nevertheless.
And or you'd have a review.
Yeah.
Well,
To give you the chance to produce the invoices, which you say you have.
well, that may be the case. That may be the case. But I think well, you've got the submission anyway as to what it is.
Yeah.
I assume you don't want me to take you through the cases of Reisdorf and Scandico unless you wish me to do so.
Well, we've looked at them, but if there are particular points you want to make
Very well, thank you.
Can I just say in relation to that I did notice that in Reisdorf itself, it seems on the facts that they did actually have the input. They did actually hold the invoices.
Yes, I think so.
So it may be a case which is worth looking at because it is a case on the facts of this case, as it were.
Yep. Bear with me for a second. So Reisdorf, page 87, I think, of the authorities body.
starts at 84.
Thank you. And my lord is correct, I think, that initially photocopies or copies of invoices were provided, and then later on the taxpayer said, oh no, I had them all along, effectively.
Yeah.
That's what it says. In my submission, the important parts of the commissioners rely on the Advocate General's opinion, which is page 90, particular, paragraph 18. The role of the invoice in the operation of VAT is pivotal. It must be issued by each supplier of goods and services to a purchaser who is a taxable person. It must be held by the taxable person at the time he claims the right to make a deduction. No issue of the content of the invoice arises in the present case, as it doesn't here, of course. And it sets out what the German law says. And then the final sentence, paragraph 18. The possibility of dispensing with the production of the original is a separate matter, more relevant to the second and third questions, which must be clearly distinguished, as it is by the National Court. So that analysis begins at paragraph 22. On page 91, final sentence. Thus, the second question asks whether the taxable person must always be able to present the invoice to the relevant national tax authorities, while the third question inquires as to the consequences of no longer holding it. Then at the top of page 92, my lord is correct, however that is not the case in the main proceedings, where it is clear from the order for reference that the plaintiff has simply refused to produce the relevant invoices despite being in a position to do so. Paragraph 25, line C. I am satisfied that the basic obligation imposed on the taxable person by Article 18, this is under the old 6th directive, to retain possession of the invoice remains unless the relevant member state prescribes other documents or proofs which may be accepted in its place. However, the other such documents must satisfy the overriding objective. Then, paragraph 26, just below line F. The plaintiff and Germany are correct to submit that the right to deduct cannot be subject to the ability of the taxable person to present the original invoice in the circumstances where he is able to produce other probative evidence in accordance with the rules laid down. I think it follows to require that persons retain the original invoice for whatever period of time they determine. And to be fair, 27, just below line H, subject only to the principle of proportionality, the court unequivocally endorsed the right of national authorities to insist on the provision of invoices of whatever information they deem necessary to prevent fraudulent claims. Now, turning to the decision of the court itself.
So, the Advocate General is of the view that it's reasonable to deny deduction if the taxable person simply refuses to produce his invoice.
Yes. Right.
And that's endorsed by the court,
well,
as I read it, at paragraph 29.
Yes, I wouldn't say, yes, has the power to require additional additional information, I say.
No, what the Advocate General is saying, if you refuse to produce your invoice, then you can be deprived of the claimed deduction. And that's what the court endorses. They talk about paragraph 27. They don't single out little bits of it.
No. No, I agree with that. I agree with that, my lord. But again, the point that I keep coming back to is what is the jurisdiction of the court in when the appellant appeals against that decision? That's what it comes down to, obviously. If we just go to paragraph 30 of the main court's decisions, that's page 97. So in the absence of specific rules governing proof of the right to deduct input tax, member states have the power to require production of the original invoice in order to establish that right, as well as power where a taxable person no longer holds the original to admit other evidence that the transaction actually took place. Now, the Upper Tribunal relied on the decision, the Tribunal decision of Scandico, and that was at paragraph 103 onwards in the Upper Tribunal decision. So that's page 89 of the core bundle. Paragraph 102, the Upper Tribunal accepts there are differences between the facts of this appellant's case and those considered in Voice, Petroma and Scandico. At 103, however, we nevertheless find case law summarised above to be of assistance, and then at Scandico at paragraph 40. So if I can invite your lordships to go to that paragraph. In fact, paragraph 39, so that's page 421 of the authorities bundle.
Sorry, we're going to
Scandico. Scandico, my lord, page 421, which is in the second authorities bundle. Now, bear in mind the facts of this case were that Scandico employed people to go into Apple phone shops, buy 2 Apple phones, because that's all the Apple store would sell to them, and were issued till receipts. And it's on those till receipts that the Scandico claimed input tax. Of course, they would never be valid VAT invoices, as accepted by the commissioners and Scandico. So this is a case where there were no VAT invoices.
Yeah. I mean, presumably the runners, as they were called.
They're runners, yes.
Posed as consumers,
Yes.
so they wouldn't get a VAT invoice.
Correct.
And they would then pass the phones on to Scandico, who sold them on.
That's absolutely correct, my lord. Thank you. So paragraph 39, bearing that in mind, that there never were VAT invoices because the commissioners had seen the invoices, the retail invoices, and had denied the input tax because they were not proper tax invoices. So at 39, page 421, the correct approach to appeals of this kind. So the appellant says, in this case, as it did before the Upper Tribunal, you have to distinguish what was said in Scandico. Because again, it was a question of the commissioners having made the decision that the evidence before that they had seen were not valid VAT.
How does this fit? If there wasn't a trade going on here, I mean, I'm just trying to work out in what sense the Apple store or Apple were supplying anything to Scandico at all.
Because for Scandico to on-sell, because the phones were in very high demand.
That's not what was happening. I mean, as I understand it, Apple thought they were supplying.
Yes.
They were selling phones to the man in the street or woman in the street.
Yes.
It wasn't a supply of goods to Scandico at all.
Well, it was because the goods were being sold to employees of Scandico who were going in there.
The argument was put forward by the FTT, wasn't it, that there was an agency here and therefore the supply to the agent was deemed to be a supply.
All right, that's the basis upon which this discussion is taking place.
Yeah.
It seems like a rather.
And as I understand it, it was the FTT who thought up that point.
I think so. Yes, I think so.
All right. Well, in that world, this discussion is taking place. Right.
Thank you, my lord. So at 39, the Upper Tribunal sets out quite rightly and it was all about the approach of the First-tier Tribunal, because the First-tier Tribunal had decided first to consider whether an actual transaction had taken place and then move on to, in the absence of valid VAT invoices, whether the commissioners had exercised their discretion fairly or not. But that's different to this appellant's case. At paragraph 40, you can see, my lords, what the Upper Tribunal says: in these circumstances, we firmly disapprove of the two-stage approach in which the parties encourage the FTT to adopt, and which has, we understand, been adopted in similar cases. So that two-stage approach is seriously flawed in judicial and practical terms. So that the factors in Scandico were different. There was no claim in Scandico that those till receipts, for want of a better word, amounted to a VAT invoice.
Well, what do you say about paragraph 41, where the submission for the taxable person, which Mr. Pickup makes, is that we're appealing against the refusal of deduction of input tax, and so we're entitled to look at anything that might bear on the question of whether we're entitled to deduct that tax. And the tribunal says there may be all sorts of decisions that lead to that result, but what you've got to look at is the decision that HMRC in fact made.
Yes. And so I think that takes me back to the original submission that I make, that in order for the commissioners to exercise their discretion, they must have made a decision that there was no valid VAT invoice, because that's the only time that the discretion can kick in.
Can I go back? I know we've looked at this already, but can I go back to Schedule 11, paragraph 4, in the context of what is said by the court or the tribunal in Scandico? That's on page 23. So
Page 23 of the decision.
No, of the first bundle of authorities.
Thank you.
So if you have that open at the same time. That says that to paraphrase, that the commissioners can ask for whatever the evidence they require as a condition of allowing the tax to be allowed or repaid.
Yes.
Now, just pausing with that a minute, they say, right, we want the invoices, and the case law shows that that's okay for the tax authority to say that. It's no answer for the taxpayer just to say, well, we're holding them and we're not prepared to hand them over. That's what Reisdorf says.
I don't agree with your logic there. I don't agree that that's what Reisdorf actually says.
Well, Reisdorf is a case where they did actually hold the invoices, didn't hand them over.
Yeah. And
the court said, well, it's in that passage we were looking at, it's okay for under local law, national law, to say that invoices actually have to be produced.
Yes, I agree.
Yeah. So here, the tax authority says, right, produce the invoices, and gives your clients a number of opportunities to do so. They don't do so. Now, supposing that the revenue just stopped at that point, no question about asking for other evidence, and said, we are not satisfied that the condition in Schedule 11.4 has been satisfied. Just imagine it pauses there. Is that not a case of the kind that's discussed in Scandico, where the revenue is just saying it's not satisfied on the evidence presented to it that there has been a taxable supply? That's paragraph 41 of Scandico.
Yes.
It's not saying there has definitely not been a taxable supply. It's saying you have a requirement to prove this as a condition of having the tax, being allowed the tax, and you haven't done that. Now, that seems to fall, to me at least, to fall flatly within the words used by the Upper Tribunal in paragraph 41. It doesn't even involve the Regulation 29 point. It's just saying we're not satisfied that you fulfilled the condition.
Well, the Upper Tribunal, my lord, at 39 does say that the Commissioner's exercised its discretion under Regulation 29.
Well, in that case, they did.
Yeah.
But why would it not? I mean, clearly, when it came to the review decision in this case, the review body also referred to Regulation 29. But I'm asking a more basic question.
Very well.
If it was, if there wasn't even a reference to Regulation 29 and other kinds of evidence weren't looked at, why isn't this just a case where the revenue is saying you've not fulfilled the condition in paragraph 4 of Schedule 11? We've given you every chance to do so. And then if there's an appeal against that, is that not a supervisory appeal?
What would you appeal against? Because there is no right of appeal against paragraph 4, Schedule 11, failure to provide.
Well, wouldn't you do what they did in Housley and say the commissioners have refused even to consider exercising their discretion under Regulation 29?
I'm sorry, my lord, I missed the first part of that.
Housley.
Housley, yes.
Wouldn't you appeal and say the commissioners have not even considered whether to exercise their discretion under Regulation 29, which was what the tribunal found in Housley?
Yes.
And this court said, well, if they haven't even considered exercising the discretion, the assessment can't stand.
Yes. But in this case,
So
they did.
wouldn't that be the taxable person's remedy in a case to which my lord refers?
Well, it would be, but
You'd say that you haven't fulfilled a condition, end of story, and the taxable person will say, well, hang on a minute, you've got a discretion under Regulation 29. You better think about exercising it.
I suppose if you are required to provide by the commissioner something under paragraph 4 and you don't, what then is the review officer to do if he or she has got no information whatsoever on which to base a decision or not? What would be the power of the commissioners? On what basis would they deny the claim to input?
Well, I'm afraid it's I who ask the questions rather than you, Mr. Brown.
Sorry, I'm just trying to assist. So there is, as I said previously, my lords, my view on paragraph 4, Schedule 11, is that then dovetails into Regulation 29, because both use the same language about providing other such information as the commissioners may require. So it would be an appeal under Regulation 29. But nevertheless, if, in my submission, if you did hold a valid VAT invoice and the commissioners requested other information, you would still appeal on the basis that you held a valid VAT invoice at the time of making the claim. Sticking with, if I may, my lords, the Upper Tribunal decision in this case, page 90 of the core bundle. This is the main paragraph that was which this appeal is subject to. Tribunal.
Paragraph, which paragraph?
Paragraph 108, my lord.
108.
Thank
Yep.
you. This is the main paragraph. The Upper Tribunal accepted that Article 178 only required upheld invoices at the time supply to have the right to deduct. Then, which we've just discussed, paragraph 4 of Schedule 11, so I don't think I need to say any more about that. And I didn't submit that the provision was overridden or inconsistent with Article 78, that's correct. And then the Upper Tribunal relied on Patroma. And similarly in this case, it says, final sentence of that paragraph, HMRC had the statutory power to require the appellant to provide the verity invoices. And as that information was not supplied, the appellant could not rely on Article 178. Now, if the tribunal there means that, because as it said at the beginning of that sentence, Article 178 only requires holding the invoices. The Troma, again, was a case where there were no invoices, or that they were actually invalid. I'm coming to the end, my lords, of this part of the submission. My learned friend Mr. Morse will address you on the additional matters. But I said right at the very beginning, I'd just address you very briefly on effectively the final paragraph of the Upper Tribunal's decision. It may have no relevance whatsoever, so please stop me. It's a very short point that I'm making. So paragraph 124 of the Upper Tribunal's decision, in this case, that's page 93 of the core bundle. Tribunal says, we also observe that in exercising its statutory jurisdiction, the FTT is well able to decide whether or not the officer acted unreasonably, for instance by requesting which was irrelevant or by refusing to accept an invoice was valid. However, this was not the case. Well, with respect to the Upper Tribunal, that's wrong, because if there's an appeal against a refusal to accept whether an invoice is valid or not, that's an appellate matter, as I've said. Well, unless anything else I can assist you with on this first half, I will defer to my learned friend.
Thank you very much.
Thank you.
My Lords, good morning.
Yes.
These submissions focus on the procedural aspects of this appeal.
Yes. This is a new point, isn't it?
It is, my Lord, yes. And it's a new point because these matters have not been explored before by either the First-tier Tribunal or the Upper Tribunal.
Right. And are they in your grounds of appeal?
The application was made, my Lord, and permission to make these submissions was given by Lady Justice Falk on the 13th of November 2025. You'll note, my Lord, that the permission can be found at tab 11, this is core bundle, tab 11, page 120.
Right.
And the application itself is in the core bundle at tab 10, starting at page 110. My Lords, therefore I submit that there is a clear answer from these procedural aspects. There is a clear answer to the point of law before the court. The First-tier Tribunal's jurisdiction in this appeal is appellate, and the appellant is entitled to rely on invoices not provided to the respondents before they made their assessments. I submit that these answers are based on previous decisions of this court, which have not been called into question, and I submit there is no good reason for your lordships to depart from them. And I submit that this approach is also the prevailing practice of the First-tier Tribunal in case managing, hearing and deciding such appeals. If I might, my Lords, just very briefly identify where I say this started to go wrong, and that if you could please turn to the first, this is in the core bundle, page 131, which is the last tab. I'm sorry, I've given you a reference. It's paragraph 39 of the first tier's decision. It's at page 131. I do apologise.
Yes.
Paragraph 39 says this: the starting point is to consider the decision made by HMRC to refuse repayment of the input tax claimed by the appellant. It is that decision that informs the jurisdiction of the tribunal. Well, as I submit, that's wrong, because what that fails to grasp, and in many ways this picks up from points put to my learned friend, is that whilst the revenue may have made a decision to deny input tax, what the revenue actually then did is issue assessments to say that the taxpayer owed, round numbers, £34 million. And we must have regard to both, because the decision of itself, my respectful submission, is economically sterile. What actually happened, and what is contested between the parties, is whether or not the taxpayer owes the revenue £34 million. My Lords, I propose to structure my submissions under the following 4 propositions, with permission permission, I'll say what they are and then attempt to make each of them good. Proposition 1. As a matter of law and of fact, HMRC issued Section 73, subsection 1 assessments for all of the VAT returns under appeal. Proposition 2.
Just a minute.
Sorry, Marlon. Yes, I should say that I haven't structured the skeleton in this way, so I should watch your lordship's pen. Proposition 1. As a matter of law and of fact, HMRC issued Section 73(1) assessments for all of the VAT returns under appeal.
Yeah.
Proposition 2. As a matter of law, this appeal engages the tribunal's jurisdiction under Section 83(1)(p), which concerns appeals against assessments. Proposition 2, that's Proposition 2. Proposition 3, any assessments subject to a Section 83(1)(p) appeal must be issued to, quote, best judgment. Your lordships will hear those words repeatedly. Any assessment subject to an 83(1)(p) appeal must be issued to the best judgment and before the correct amount of tax actually due from the appellant. And my lords, that's because, and the proposition continues, finding the correct amount of tax due under the assessment is the tribunal's primary statutory function. That of itself is an appellate jurisdiction. Before I get to 4, in order to succeed on this aspect, and in our respectful submission, succeeding on either set of arguments results in this appeal succeeding, I need your lordships to be with me on points 1 to 3. Proposition 4 is made for 2 reasons. Proposition 4 is it's responsive to what my learned friend says in the revenues responsive skeleton at paragraphs 8 and 9. And also it's a further reason why propositions 1 to 3 are correct. Proposition 4 is this. Properly understood, in any event, this appeal challenges the assessments raised on best judgment grounds and on quantum grounds, thereby itself engaging the tribunal's appellate jurisdiction.
Sorry, can you say that again?
Yes. Proposition 4. Properly understood, in any event, this appeal challenges those assessments on best judgment grounds and on quantum grounds.
And on what grounds?
Quantum. I'm sorry, Mark.
Yeah.
Quantum. Which itself engages the tribunal's appellate jurisdiction. Those are 4 propositions. I need your lordships to be with me on 1 to 3 as a minimum. Proposition 1, we say the revenue issued Section 73(1) assessment. I understand, my learned friend, not to contest, I'll be corrected on this, not to contest that Section 73(1) assessments have been issued where the original VAT returns were a payment return, where a net amount of tax was due. I'm getting a nod.
Yes, I think there are two periods, I think.
Correct, my lord. So unfortunately, I will need to address your lordships on why we say there are Section 73(1) assessments for all of the VAT returns, because, my lord, the submission is this, that the revenue issued 73(1) assessments for all of the VAT returns, including, as your lordship mentions, the 2 repayment returns, which were the ones for August 2018 and November 2018. So this plainly then begs the question as to what is an assessment for Section 73.
My Lord, forgive me, just to save my learned friend having to go over that ground, I do accept that Section 73 VAT assessments have been issued for all VAT periods, VAT returns. The only point in the skeleton is that some of them were also denials of input tax that didn't require assessments because they were pre the returns being authorised. So you'll see that some were input tax denials adjusted on returns, and there were also assessments for those VAT periods. So insofar as my learned friend says there were VAT assessments for all VAT periods, that's not disputed.
Right. So it's common ground that there were assessments for all relevant VAT periods.
Yes.
Is that right? Yeah.
I'm very grateful. My Lord, in those sections, I'm very grateful for that indication. Perhaps the course I'll take is this. I will state, because it will hopefully assist, I will state my 5 propositions as to what an assessment is for Section 73 purposes, how one knows that one has been made, and I will then address the point that now appears to be in contention by reference to the authority ARIA technology. So I'll state the proposition, give you the references, but move quickly on to the point that I understand to be in dispute. So there are 5 points, my lords, as to what is an assessment, or to answer that question, what is an assessment for Section 73 purposes. 1, and this may well be common ground, there is no, proposition 1, there is no statutory definition contained in Section 73 itself or elsewhere. 2, previous decisions of this court have decided that an assessment is, in general, a legal act on the part of HMRC which determines a net amount of VAT due to HMRC. I think that's the point that divides us on the repayment returns, which I will come to very, very shortly. 3, the minimum legal requirements for there to be an assessment are to state the recipient's name, the net amount of VAT due, the reason for the assessment, and the VAT periods to which it relates. 4,
Just a minute.
I'm sorry, Lord. So 3, the minimum legal requirements, state the name, state the net amount of VAT due, state the reason for the assessment, and state the periods.
Yeah.
Point 4, well, as this is important for all of the matters, a Section 73 assessment is for the net amount due. It is not for any amount of input tax, output tax, or a combination which makes that up. It is not an assessment, therefore, for either input tax or output tax. And a previous decision to that effect has been specifically overruled. 5, we get to the answer of that through an objective analysis for which no formality is required. An assessment may be contained in multiple documents taken together, as we say happened in this case. The key question is always whether the matter is clear to the reasonable reader of the documents. Very briefly, my lords, just to ground this, and I won't dwell on the matter, but just to very briefly, if I haven't been shown Section 73 bears, I could very invite you please do so. That's in the first volume of the authorities bundle. I should apologise that the tabbing is somewhat idiosyncratic. It's not numerically sequential, which we noticed only after they'd arrived at the courts, which I do apologise. Page 13, 1-3.
Yeah.
Your Lordships will find Section 73, where a person has failed to make any returns required under the Act, or to keep any documents and afford the facilities necessary to verify such returns, here's where we're concerned, or where it appears to the Commissioners that such returns are incomplete or incorrect. The point, my Lords, being this, is having decided what the Revenue decided concerning the documentation, the Revenue exercised their powers under section 73(1) because it had then appeared to the Commissioners that our returns were incorrect. Where so, the Revenue may, don't have to, the Revenue may assess the amount of VAT due from him to the best of their judgment and notify it to him. That's the basic provision. There are two key authorities, my Lord. I will, if I may, give you the references to Bupa purchasing, because I think I should concentrate on ARIA technology, given what I now know is not in dispute. If I could just invite, we're staying in volume 1, idiosyncratically for hard copy, it's tab C7, electronically page 264. Bupa purchasing, a decision of this court. Lady Justice Arden, as she then was, giving a single judgment with which the other members of the court agreed. Facts not particularly significant in my submission. Therefore, could I invite you please to turn to page 275. And at page 275, if I could invite your lordships to note, I'm happy for you to read them now, but if you could either read now or note, please, paragraphs 36 through to 42 on the following page.
Yes.
Perhaps, my Lord, what may assist is if I identify now the points of particular relevance that I wish to highlight. Those are these are all on page 276. So it's the bit of paragraph 38 on page 276, second line. If the taxpayer contends that he is entitled to a repayment of VAT, noting that significant material difference between a return that says I owe you money, HMRC, and a return that says you owe me money and I would like a repayment of that. Lady Justice Arden is drawing a distinction between those two scenarios. If the taxpayer contends that he is entitled to a repayment, he will have to appeal on some other ground, such as against the amount of input tax allowed, and VATA makes express provision for this in section 83. In my submission, that is section 83, subsection 1, subsection C. 83(1)(c) is what her ladyship has in mind there. The other passage, if I may, my lords, is that the final sentence of, we rely on all those paragraphs, the contents, but in particular the final sentence of paragraph 41. These figures, the constituent figures, form part of an assessment, but they are not the figures that make the act of the Commissioners an assessment for the purposes of 73(1). We also...
Was there a point about 73(2) here or not?
My Lord, no.
Isn't that to do with this case? No.
No.
Do you want to explain why briefly?
For two reasons. One, we are here dealing with the assessments issued under section 73(1) because they are for amounts of VAT due, and 73(2) concerns recovery assessments where amounts of input tax had previously been refunded.
Oh, I see. Thank you.
And I think I'm just going to ask your lordships to note on page 280, we rely on what Lady Justice Arden says at paragraphs 62 and 63. That's the overrule point. This is the proposition that Section 73(1) assessments are for the net amount of VAT that is indicated as due. Moving on then, so we say the same is also true where the original return showed a net repayment. This whole matter started because the taxpayer filed its August 2018 return showing a small net repayment of, I think it was 60 something, 64,000, which triggered an inquiry. So we say that when HMRC make a determination that turns a repayment return into a net payment due, going the other side of zero, is also the issue of a Section 73(1) assessment. And the authority for that in my submission, my lords, is ARIA Technology. That's at the final tab of Volume 1, starting at page 315. It's another decision of this court, another single judgment, this time Lord Justice Singh, with whom the other members of I'm sorry, Lord.
ARIA.
I do apologise, my lord. I didn't pick that up. ARIA Technology.
Where's that?
The first volume of authorities, tab 9, page 315.
I think it's in our second
I
volume.
think it's in our second volume.
Oh, I do apologise.
That's right.
That will make any other subsequent tab numbers run out as well. I apologise, my lord.
Right, ARIA.
So page 315, ARIA. Another decision of this court, Lord Justice Singh. Briefly on the facts, if I may, my lords. Paragraph 1, which is at page 317. Lord Justice Singh, therefore, is concerned with the meaning of an assessment for these purposes in this appeal. The context being the Revenue's decision to deny a claim for input tax in a substantial amount. Paragraph 6 over the page makes that good. So paragraph 6, the numbers will get terribly confusing. So for these purposes, it was a repayment return, paragraph 6. Paragraph 7, the Revenue issued a decision to deny input tax in an amount that exceeded the net refund originally claimed.
Sorry, where are you?
Paragraph 7, my lord.
7.
Page 318. So we start as a repayment return. Revenue come along, deny input tax recovery in an amount that exceeds the original repayment. HMRC write to the taxpayer saying, you owe me a substantial amount of money. There is, in Section 73 terms, a net amount of VAT due to the commissioners. That's summarised in my submission at paragraph 8, that we've moved from net repayment. We start with net repayment, HMRC disallow input tax, exceeding that net repayment. We then have what is colloquially a payment return. Moving forward to page 324. Paragraph 43. Paragraph 43 is the authority for the minimum requirements proposition I made a few moments ago. Paragraph 44, Lord Justice Singh rehearses, reiterates, adopts what Lady Justice Arden said in the purchasing.
Yeah.
My Lords, I think in the second, I think I should invite your Lordships. It's a long passage, but could I please invite your Lordships to read paragraphs 45 to 49, which is on page 325. And when you do so, my Lords, could I just invite your Lordships to bear 3 particular points in mind as you do so. One, the concept of a reasonable reader of documents as to whether a Section 73 assessment has been made. 2, that this is an objective analysis. 3, ultimately, this is a matter of the fair administration of the tax system. So, Milos, perhaps if you might read those paragraphs.
Yes.
I'm obliged. The conclusion from all of that is very simply put, my Lords, as paragraph 64 on page 328. Your Justicing's conclusion on their true construction, this is paragraph 64 on page 328. On their true construction, those letters did record an assessment within the meaning of section 73.1. The proposition then being whether one starts with a payment return or whether one starts with a repayment that's turned into a payment return, one ends up with a section 73.1 assessment. Taking all those points together, my Lord, I submit that's the relevant legal framework that determines whether or not HMRC have, in fact, made a section 73.1 assessment. That's also, in my submission, the approach that FTT panels take. One should think very carefully about referring to first-tier tribunals in the Court of Appeal. We set out at paragraphs 46 and 47 of our skeleton, core bundle, tab 3, page 41. I don't propose to invite your Lordships to turn them up. But the submission is this is the approach taken by first-tier tribunals. Applying that legal framework, my Lords, I submit that HMRC did in fact issue section 73.1 assessments for all of the VAT return periods. And we say that through the combination of, perhaps for your note, if I just tell you what they are and where they can be found, the combination of the following. HMRC's letter dated the 7th of January 2019. These are all in the supplementary bundle. Supplementary, tab 15, page 74. 2, HMRC's letter 25th of January 2019. supplementary, tab 17, page 79. 3, both of HMRC's letters dated the 6th of February 2019, which are successively tabs 18 and 19, pages 81 and 84. And finally, the schedule dated the 6th of February, which you'll find at tab 20, page 86. Now, some of these you've seen already this morning. Given the indication from my friend, I don't propose to show them to you either again or at all. The submission model, I think the point is made in the skeleton in any event, if required, that the reasonable reader would understand that these were Section 73.1 assessments. It is worth, in my submission, if I may, please to draw your Lordship's attention to the schedule. So if we could please turn up the supplementary bundle, tab 20, page 86. So supplementary bundle, tab 20, page 86. That is the schedule attached to the 6th of February 2019 letters. There is some, be generous, scribble around the August 18. Our understanding is that is taxpayer scribble. It wasn't like that when it was first issued, but that's the document the parties have.
And this schedule, this was one that Officer Mills provided, is that right?
That's right, my lord, yes. It was the schedule to...
His letter of the 6th of February?
Correct. And is referred to. So I'd simply ask your Lordships to note the following. 1, you can see the VAT periods, including the original repayment returns, now showing positive amounts. 2, the reasons, and actually the two separate assessments, the preferred and the alternative. 3, the figures at the bottom, the large numbers, the amounts due for each of them. I'm reliably informed that those two figures add up to the 34 million odd. So we say any reasonable reader would understand all of that the revenue had issued them, this, as a corporate, with Section 73.1 assessments. In passing...
Well, isn't that clear from the letter on page 84?
It is.
I have made assessments of VAT due under Section 73. This letter and the enclosed schedule is our notice of those assessments. Look at the schedule and you've got all these various periods.
Quite so. I was merely making good the proposition from earlier, but I would also, the particular reason for asking your Lordships to turn it up is this. In passing, I would invite your Lordships to note that here we are at the 6th of February 2019, and we are concerned with the earliest VAT period ending on the 31st of May 2016. Therefore, my Lords, at this point, there is still 18 months to go before we get anywhere near the 4-year limit for anything going out of time for an assessment. And my Lords, I submit that is significant in this appeal for reasons of the best judgment. So in conclusion on Proposition 1, my Lords, these are the reasons for which we say the revenue issued 73.1 assessment. Proposition 2, as a matter of law, this appeal engages the Tribunal's jurisdiction under Section 83(1)(p), appeals against assessments. And I can probably deal with this relatively briefly. Authorities 1, please. Tab 1, page 17.
It's common ground, is it, that 34 million is wrong?
It's an agreed amount insofar as I understand that was the amount assessed.
I thought they were alternative
I'm
assessments.
sorry, I understand the point. They are alternative assessments. We can't in total end up owing 34 million.
No. So when it says you owe us 34 million, it's common ground that it means one or the other.
Correct.
So we're going to section 83, are we?
I'm going to invite your lordships to look at section 83, which you'll find at page 17.
Yeah.
Very briefly, an appeal shall lie to the tribunal with respect to any of the following matters. So an appeal can potentially cover 2 or more. Doesn't usually, but it's possible. And the 2 which, what I say, this appeal concerns subsection sub P on page 18, bottom of page 18.
Yeah.
Which I submit is either the facts of the assessment or its amount.
Yeah.
I should, in fairness, also identify to your lordships at this point, 83(1)(c), the amount of any input tax which may be credited to a person.
Yes.
Staying in authorities, well, I hope this is in your lordship's version of authorities 1. It's page 212. I think I'm still on safe ground. In 1. Pegasus Birds. Decision again of this court in 2004. Very well known case. 2 substantive judgments by Lord Justice Chadwick and Lord Justice Carnwath, as he then was. I'll be coming back to Pegasus Birds in a moment, but just for now, please, could I draw your lordship's attention to paragraph 85, which is on page 235. It's at the bottom of that page, bottom of 235. Could I please invite your lordships to read paragraph 85? That's the bottom of 235 into 236. The point of emphasis, my lords, is this, the final sentence. Second, an assessment under section 73(1) engages and is subject to the appeal provisions in 83p. I think that's meant to mean 83(1p). And that's Lord Justice Chadwick saying, in my submission, as a matter of law, appeals against 73(1) assessments engage 83(1p). I can also deal, hopefully similarly briefly, with the point against me in relation to 83(1)(c). Lady Justice Arden dealt with that in her judgment in Bupa Purchasing. I think I've made that submission to you already. Her Ladyship says you
don't think you showed us what she said about 83(1)(c). Just remind me, where do we find Bupa? That was in volume 2, was it?
I think it was, my lord.
Sorry, no, it's in tab 7 of that.
Tab 7.
Yes.
Volume 1, I think.
Right.
So it's at page 264 in any event.
Yes. Right, what does she say about 83(1)(c)?
Paragraph 38, page 276.
No, that's when he's contending for a repayment.
So, correct.
Yeah.
So I submit that's the express provision. I think my notes have gone slightly out of order. I already made that submission
Yes, you have. Yeah.
Well, also, I also submit that this deals with the trade court case relied on by my late friend Mr. Watkinson. That it's in my first bundle. It's at page 238. under my tab numbered 5. This case concerns the consequences of non-payment by the revenue of net repayment returns, where HMRC believe they have reasonable grounds to suspect the taxpayer of being involved in MTIC fraud. HMRC conducted extensive inquiries into those net repayment returns. They said they should be refunded the money and brought judicial review proceedings, which were dismissed. If I could just please invite your lordships to note that here we are only concerned with repayment returns that stay as repayment returns. And I invite your lordships to make that conclusion by paragraphs 1, 6, 13.
Just a minute.
I'm sorry, no, paragraph 1 on page 241. Paragraph 6 on page 243. Paragraph 13 on page 247. Paragraph 18 on page 249. And finally, paragraph 19. I'd also invite your lordships to note that from the head noting at pages 240 to 241, Pegasus Birds was not cited to the court. So the submission is this: different facts, different scenario, different legal issues, and therefore the case should be distinguished. That concludes Proposition 2, my lords. Proposition 3.
So sorry, what did this one decide?
It decided the revenue could take their time to validate the repayment, but it did not concern the raising of assessments or the making of assessments. So the case concerned input tax, but it did not concern an assessment. And here, on my submission, it's common ground for all but 2 of the returns. We are concerned with 73.1 assessments. I say for the original repayment 2 returns, they are also 73.1 assessments. See Lord Justice Singh and Aria. The point is, the case is relied on by my learned friend. I say it's about something else.
Right. So your proposition 3, if I've noted it down correctly, was that any assessment must be issued to the best judgment of HMRC and for the correct amount of tax actually due, and finding the correct amount of tax due is the FTT's primary function.
You have that precisely, my lord. It is, and therefore it is an appellate jurisdiction.
Yeah.
Authority Pegasus Birds, page 212. Hopefully still, well, it should be in your authorities 1. Please turn to page 219, paragraph 21. You will see at paragraph 21 on page 219, Lord Justice Chadwick noted the wording of 83, insert 1p, reflected the 2 distinct questions, and then the indented text. First, whether the assessment has been made under the power conferred under that section. And second, whether the amount of the assessment is the correct amount of tax for which the taxpayer is accountable. So that's the jurisdiction. So therefore, what is best judgment? We say it's this. We say that test is met where the tribunal is satisfied that there has been an honest and genuine attempt to make a reasoned assessment to calculate the amount of VAT properly due from the taxpayer.
Yeah, I mean, there are statements in this case which seem to point some of the time in different directions. I mean, if you go on from the bit that you've quoted in paragraph 21 to what Lord Justice Chadwick then said in Rahman, in the second quotation, he says that explanation may be that the tribunal applying its own judgment to the same underlying material at the second or quantum stage. That seems to be the same underlying material that HMRC had when making the assessment. And he goes on at the top of the next page. Explanation may be the tribunal satisfied the commissioners have made a mistake, that they have misunderstood or misinterpreted the material which was before them.
Yes.
Paragraph 22 between D and E, Lord Justice Carnworth now, talking about the obligation of the commissioners fairly to consider all material placed before them. But then in other places, they seem to be suggesting that it's not just what the commissioners had when making their assessment, but additional material
Yes.
which is produced the tribunal. When you get to the guidance which Lord Justice Carnworth gives us at 38, that's
38. Yes.
he says, Roman 1, the tribunal should remember its primary task is to find the correct amount of tax so far as possible on the material properly available to it. He doesn't tell you what is the material that is properly available to the tribunal.
Yes.
And when he goes on to look at the facts of the particular case, the tribunal's conclusion, which he quotes at paragraph 53 between A and B, is that all the matters to which we have referred in the last 5 paragraphs were there for Mr. Bakewell to consider. So that was material that was before the commissioners.
Yes.
And I think he comes back to that at paragraph 58. So it's not entirely clear from this case
Yes.
what it is that is properly put before the tribunal when challenging a best judgment assessment.
Yes. Well, if I may.
So it's right to say, as you say, Lord Skeleton, that subsequent cases have said that there are 2 stages. On the material, did the commissioners exercise best judgment? And stage 2, on all the material, including additional material, was the assessment correct?
Yes.
Whether you get that very clearly out of Pegasus birds, I think, might be open to question.
Well, my lord, if I may I'll tackle that point, if I may, and make the following submissions. Your lordship is right that one can read some of those passages one way or t'other. If I may take your lordships through the order in which I say it becomes clear through the authorities and the prevailing practice of the FTT in looking at these matters that one is not restricted only to that which was before the revenue when they made their decision. Before I do that, my lord, if I could invite your lordships to consider this situation. The revenue write to me today and they say, I want by tomorrow all of your VAT invoices. And if you don't produce them by tomorrow, I'm going to disallow all of the input tax that you've ever recovered. Now, if the revenue are right, then all I would be able to do in that situation, if I fail to comply with that, all I would be able to do is bring a supervisory appeal to the First-tier Tribunal or seek judicial review proceedings.
Yeah. Well, speaking for myself, I don't find these extreme examples helpful, because you give an extreme example and a successful challenge to the exercise of discretion is much more likely to succeed.
Yes.
I mean, the more realistic example is after months and months of asking for the documents, the taxable person still fails to produce them, and then the revenue says, all right, well, we're going to disavow it.
Yes.
Now, there's nothing terrible, is there, on those kind of facts in saying, well, you've had umpteen chances to produce them, you could have produced them to the officer, you could have produced them to the review, you didn't.
Yes. So, again, I'll come back to evidence, but I'll take that point, if I may, first. It's the DCM optical case in the Supreme Court, Lord Hodge, paragraph 35. We can turn it up when I find it in the notes. There the court was dealing with an uncooperative taxpayer, but the court said it made no difference to the matter of jurisdiction. Whether or not the revenue have acted wholly unreasonably, and we say, punchline, we say that from a best judgment perspective, the fact that the revenue did what they did over a very short period of time, when we say all of the evidence was made available to them, but they declined to inspect the records, we say all of these matters go to whether the assessments were raised to best judgment. And my lord, in my submission, that is of the first of the two questions to be tackled under a section 73(1) appeal.
Is that in your grounds of appeal to the FTT?
It is in the grounds for which Lady Justice Falk gave us.
No, your grounds of appeal to the FTT.
The submission, and this is the point 4, we say, so proposition 3 is, as a matter of law, 83(1)p is appellate, and the FTT is entitled to take into account new material. Proposition 4 is, we say, in any event, properly understood, that this is a challenge on best judgment grounds. Let me tackle the evidence point.
Right.
Lord Justice Chadwick's judgment makes clear that, in my submission, that it's the evidence that was available to the revenue, not just that which the revenue had when the revenue decided to make the assessment. And to make that good...
So just say that again.
Yes.
You say the proposition is that whether an assessment is correct,
whether it's to best judgment,
it is to
and then to quantum,
to best judgment on quantum.
Best judgment, test 1, quantum, test 2. So your lordship put the point of same material. I submit that his lordship meant it's the same material to decide quantum as to determine whether or not it was to best judgment. His lordship did not mean it's only the same material that the revenue had when they raised the assessment.
Well, I don't understand that. How can you attack the exercise by somebody of best judgment by reference to material which they didn't have and couldn't have had?
Because the courts have decided that circumstances where the revenue have cut corners, done things too quickly...
Well, that's different, but they haven't. They haven't cut corners. They've considered carefully all the material that was presented to them. They have reached a decision, and you now say, well, I've got more material, which you didn't have at the time, which shows that the quantum is incorrect. I understand that.
Yes.
But how can that impugn best judgment?
So best judgment, successful best judgment outcomes are relatively rare. But we submit this as a case. When we get back to the FTT, this would be a case where that point would be run. That, as Mr. Brown showed you this morning, the facts are that the revenue acted with some haste, and we will close their mind to material that was available to them, they declined to look at before they made their assessment. Well, this is rather, I'm sort of getting ahead of myself. I still need to answer your lordship's question on evidence and the material that's available. And if I could do that, please, by inviting you to turn to page 232 and paragraph 72. 72.
Yeah.
And just above the letter E on the right hand side, there's a sentence that starts, the issue. The issue raised by this is paragraph 72 on page 232. The issue raised by this appeal is whether, in the exercise of the 73(1) power, more is required of the Commissioners and an honest and genuine attempt to make a reasoned assessment of the VAT payable. This is the point of emphasis. On the basis of the material then available to them. Paragraph 87, which is on page 236. This is, it starts at letter C. This is Lord Justice Chadwick referring to his judgment in Rahman number 2. And there you have by letter E, so in the indented text, just after the best judgment requirement, his lordship says this: for example, where the commissioners have not taken into account information which was made available to them by the taxpayer before the assessment was made.
Could I just give you an opportunity to put in a nutshell the suggestion that there was haste in this? I appreciate we're not ruling on this point, but you're illustrating what can arise in these types of situations. So what is the timeline, as you would put it, that illustrates haste?
So haste, well, from a best judgment perspective, the relevant facts, I have to bring it back to the facts, my lord.
Yes, that's what I'm inviting you to do. Not at length, but just in order to encapsulate it.
I'll attempt to do so. So the revenue's power to assess is subject to time limits. For these purposes, it's 4 years, effectively, from the end of the VAT return period. It is common for both taxpayers and HMRC to pay close attention to those time limits for the obvious fiscal effects of being one side or the other. And that's why I showed your lordships the schedule, is that at the time the assessments were raised, which if the revenue are right brings the shutters down on what we are then able, what the appellant is then able to bring by way of challenge to quantum, that the revenue had more than 18 months still to go before there was any risk of any periods of time going out of time. So that is why it is at, if the revenue are right, that is why it is at haste, because the revenue are in control of the timeline. And I understand you're making a submission saying they could have gone on for over a year more. In other words, the bar didn't drop in limitation until 18 months, fine. But I thought you were making a submission that they, in a sense, were making unreasonable demands at speed. Well, we do also say that, my lord, and that is proposition 4, that when looked at, the grounds of appeal do say the revenue acted unreasonably, and that the unreasonableness was to ask, first of all, to ask for the amount of information that they did before they made the assessment, and then when that information was made available to them, by way of inspection of the principal address, which is the statutory requirement of a taxpayer, the revenue declined the invitation to do so. So we say all of those things are relevant to whether the assessment was ever made to best judgment in the first place. That is a matter for the FTT evaluating all of the evidence that's available.
That would also go to the section 20, the regulation 29 discretion, wouldn't it?
Yes. But we are here, these submissions relate to what the revenue actually did, which is to, so when one has a section 73(1) appeal, submission proposition 3, in all circumstances, that's an appellate jurisdiction. Because the assessment is never for input tax or output tax. It's only ever for a net amount of VAT.
I thought that input and output tax on the authorities you've shown us were part of the assessment.
Correct. But what Lady Justice Arden said is that they are not the amounts that are assessed. What is assessed is the net amount of VAT that's... So you don't have an input tax assessment or an output tax assessment. You have a VAT assessment. The reason for issuing it may relate to one or the other, or in many cases both. But the assessment is only ever for, as a matter of law for a net amount of VAT, and it is not for input tax or output tax as a matter of law. So just to finish the point on evidence, paragraph 77, page 233, just above letter H, that is an evidential inference from the facts. That can only be done on an appellate jurisdiction, and we've established that it is, if the tribunal tasked with that two limbs of the test, is it to best judgment? If not, then well, the submission is this. That the tribunal, if the tribunal's statutory function is to determine the correct amount of tax due, it can only do that if it can take into account all relevant material. That necessarily must include material that was not before the revenue when they made their decision.
Well, you say that, but where do you get that from in Pegasus Birds?
All available material, my lord. It was the paragraph 72 and paragraph 87.
Well, I'm not sure I quite follow that. Paragraph 72. Lord Justice Chadwick says, the issue raised by this appeal is whether in the exercise of the Section 73 power, more is required of the Commissioners than an honest and genuine attempt to make a reasoned assessment of the VAT payable on the basis of the material then available to them.
Yes.
Is it enough, as the judge held, that the officer does his honest best, or is there some objective standard, so that if the officer fails to attain that standard, there has been no proper exercise of the power to assess? The judge held that it was enough that the officer did his honest best, and the appeal against what the judge held was dismissed. So how does paragraph 72 support your argument?
Yes, what I believe I should have done is also ensure that I drew your lordship's attention to paragraph 38. And in particular, so if I could ask you please to go to page 224, which is the guidance to the tribunal.
Yeah.
Heading, paragraph 38.
Yeah. On the material properly available to it. But that doesn't tell us what that material is. Now, I think it is fair to say that at paragraph 17, quoting from his own decision in Rahman, Lord Justice Carnworth does talk about further evidence available to the tribunal. But whether that actually finds its place in the end is, to me, at any rate, not entirely clear.
I accept that, Lord. The submission is that is also the prevailing practice.
Yes, that I can understand.
And the other passage I think you referred to is paragraph 87 at 236, where Lord Justice Chadwick does seem to, in the quote from paragraph 44 of Rahman, Lord Justice Chadwick does seem to envisage that there may be evidence which wasn't available to the commissioners.
I'm grateful, my lord. Indeed, indeed, it is that passage. So this is page 236, paragraph 87, just under the letter E, where for example, where the commissioners have not taken into account information which was made available to them by the taxpayer before the assessment was made.
Well, I thought it was more actually the next paragraph, 44, rather than 43, because he actually seems to be talking about the evidence before the tribunal there.
Yes, well, That is in paragraph 86, on which we rely. So yes, we agree. There is an example, emphasis example, in the skeleton where this point is specifically identified. That's the Roscoe-Noonan decision. I accept, my lord, it's a first-tier tribunal decision. However, of course, so that decision was the 24th of January 2025. It has not been appealed. Perhaps in the interest of time, I could simply invite your lordships to have regard, please, to paragraphs 36 and 64.
So we're looking at Noonan, are we?
We are. So page 583. So that's definitely authorities 2. This is Noonan starting at page 574. Excuse me. Getting to the nub of it, paragraph 64 on page 583. 64 is a long paragraph that starts just above the hole punch that quotes from Rahman and Mithras. So what I would invite your lordships to
the quotation is from Carula, I think, isn't it? I was trying to work out where the quotation comes from, and I think it's from Carula.
Your lord may be right. I thought it was Mithras, but
no, I think it isn't. I think I looked at Mithras as well because I thought originally that might have been the source, but it isn't. It's Carula, and interestingly, in Carula, the application before the Upper Tribunal was an application to admit fresh evidence on appeal to the Upper Tribunal, which they granted. So it does rather underline the point that at any rate in the tribunal, it is not restricted to evidence that was before the commissioners, or even for that matter before the FTT.
Quite. Well, paragraph 7, the quoted paragraph 17 in any event, my lord, is that upon which we rely.
Yeah.
And my point about Mithras, perhaps I got mixed up with the reference to Mithras in paragraph 17.
Yeah, no, Mithras does go through the authorities.
Yes.
And that's what Sir Stephen.
Quite so. So the point being, at the second stage, the quantum stage, the tribunal has a full appellate jurisdiction. It can therefore consider all available evidence, including material not available to HMRC at the time when the assessment was made, in substituting its own judgment as to the correct amount of the assessment. Drawing that together hopefully in a single sentence is, if it is an appellate jurisdiction, and it's the tribunal's statutory function to decide what is the correct amount of tax. Logically, my lord, it can only do that if it has available to it all evidence that goes to quantum and goes to best judgment.
Yeah.
Well, those are two separate points, aren't they? Because the reason why analytically they're divided into two is that they are separate criteria. And the slight difficulty I have at the moment is understanding how the best judgment test can be seen, as Lord Justice Chadwick seemed to suggest, as being answered by asking the question, what amount of tax is properly due from the taxpayer, which seems to be an entirely different question.
Not quite, my lord. The best judgment, so the two tests, the test one is the assessment to best judgment. That's answered by, is there an honest and genuine attempt to get to the right answer? What the courts then go on to say is, an assessment may be, that the quantum may be so far off what's correct that the assessment could never have been an honest and genuine attempt in the first place. The submission here is that because this appeal engages 83(1)p, the jurisdiction of the FTT is appellate, even if the tribunal decides that there has been an honest and genuine attempt to raise an accurate assessment, it is then the tribunal's statutory function to decide what that correct amount of tax due from the taxpayer actually is. And the tribunal can only do that if it has available to it all relevant evidence as to quantum.
You're going to come on to Cohen's-Ad and all those cases at some point? No.
My lord, no. I wasn't intending to.
All right. Well, can I ask you about Cohen's-Ad? Let's start with Cohen's-Ad. Page 152, I think, in our bundle.
My lord, I fear that I should defer to my letter from Mr. Brown on Cohen's-Ad. I'm very happy for you to do.
No, it's a question for you, I think, Mr. Morse.
I'm sorry, my lord.
I think it's a question for you. If you go to page 153, judgment of Mr. Justice Sheeman. This is the case which sets off this whole line of cases about supervisory jurisdiction.
Yes.
And you'll see he opens his judgment by saying, this is an appeal against the decision of the London Value Added Tax Tribunal. The tribunal dismissed the appellant's appeal against the Commissioner's assessment.
Yes.
He must have been wrong, must he not, on your analysis, to say that the jurisdiction was supervisory only because there was an assessment.
Yes.
Boyce is another one where there was an assessment.
Yes.
Housley was another one where there was an assessment.
Yes.
So that whole line of cases on your analysis is wrong. I think Tower Bridge was another case where there was an assessment. You can't quite tell that from the judgments of this court, but you can from the decision under appeal. And the only one which I've not been able to track down is Scandico, where I can't work out from the report whether there was or there wasn't an assessment.
Yes.
But the implications of your submissions are that all these cases were wrong.
My lord, yes, when one is dealing with a situation where the revenue have come along, made a decision concerning input tax or output tax, but said here is a demand for money.
Yes.
So we know.
I understand that. I'm just trying to work out the implications. If you go on to page 154 in Cohen's-Ad, you will see that Mr. Justice Sheeman refers both to an appeal against the amount of input tax and an appeal against an assessment. And in just before the quotation, he described those as the following presently relevant matters. So he's clearly got in mind
Yes.
the fact that there was an assessment.
Yes.
And here is an appeal.
Yes.
Now, is there a case in which Cohen's-Ad has been disapproved for getting the answer wrong? Because on your analysis, it seems to me that it must be wrong.
Well, just to tackle those points in turn, Cohen's-Ad was plainly before the decision of this court in Pegasus Birds.
Mm-hmm.
So, and it was Pegasus Birds that overturned Ridgeon's bulk that said the assessment was for input tax or for output tax. So, in my submission, Cohen's-Ad in these particular circumstances is wrongly decided on those grounds. Because when one is dealing with an assessment, a Section 73(1) assessment, repeating myself to your lordship,
Yeah.
the jurisdiction is appellate. Tribunal's function is to find the correct amount of tax. Very briefly on Tower Bridge, it's in the disclosure First-tier Tribunal, reference 2016 UK FTT, page 54. Your lordship is of course right, you need no lectures on Tower Bridge, but in those disclosure proceedings that concerned VAT assessments, at paragraph 11 of that decision, the tribunal says that it has an appellate jurisdiction. The assessments in, I was trying to work this out this morning, the assessments in the main appeal, FTT reference 2019 UK FTT, page 176, of the 5 issues that were started, that by the Upper Tribunal came down to the first two, it does not appear that the point was ever taken that there were appeals against the assessments engaging Section 83.1.
No, and it was common ground in this court that it was a supervisory jurisdiction.
But the point was never taken,
No.
my lord, because issue 1 was whether there were valid VAT invoices. Issue 2, reasonable discretion. Issue 3 was whether they knew it was the Kittle point. The assessment question, where the court gets close, the tribunal gets closest, is issue 4, which concerned whether there was a Section 73 assessment that had been made. And issue 5 was whether the assessments were made in time or not. So the point was never actually ventilated, my lord.
No.
I am very conscious of the passage of time. So, my lord, I think we are coming very much to the end,
Right.
perhaps mercifully, of proposition 3. I should very briefly, can I ask you please to look at DCM, or one paragraph in DCM Optical Holdings. That's definitely authority 2. Page 364. So that's where DCM Optical Holdings starts. Facts not particularly relevant for these purposes. If I could please just invite your lordships to turn to page 377. And where you'll see paragraph 35. The submission I was making earlier is that here Lord Hodge is dealing with the point that where you have a net payment VAT return, there is the potential for HMRC to run out of time to make the assessment. Point of emphasis being the final sentence, where, not least where, as here, the trader has been uncooperative. His lordship doesn't then go on to deal with whether that of itself could or should determine the relevant jurisdiction when HMRC have exercised their powers to say that that lack of cooperation has fiscal consequences.
It might be said that there's something rather arbitrary about your submission, because as I understand it, you're saying that in a case where the taxpayer is saying it's entitled to the repayment of input tax, you'll be in a subparagraph C case. Whereas in the case where the boot is on the other foot, so the revenue is saying overall the net amount is payable to us, it's an assessment case and therefore within P. That seems to be your submission. But that seems arguably rather arbitrary, because that will just depend on how much output tax there happens to be. And why, supposing that the output tax is the same, in other words, there isn't a battle about that, you get these radically different results depending on what the amount of the output tax is, where that's not actually the question about which the revenue has made a decision. And that strikes me as rather an arbitrary and irrational distinction at the moment.
So I accept that it may appear that way. What Parliament has done in setting out the appeal gateways in section 83 is to state very clearly in our submission that when it is the revenue coming along saying there is an amount due to the state, that engages section 83(1)(p), full stop. We saw that with Bupa purchasing. And the decision of this court, the same decision, Lady Justice Arden said, if you're in a net repayment position, it's an 83(1)(c) appeal. It could also be an 83(1)(c appeal, my lord, in this situation. I file my VAT return showing a net amount due, but I've held back invoices because I don't think they qualify. I put them to HMRC, so my return is correct because it's the appearance to the revenue as to whether the return contains errors that triggers the assessment power. We saw that in section 73. So one of the reasons why it's not arbitrary, my lord, is in that situation, and why this becomes an 83(1)(c appeal, is because the revenue say, no, you're not entitled to that repayment. There's nothing wrong with my return. My return is correct as far as the revenue is concerned. The revenue have no basis to issue an assessment. But I can still challenge the revenue's refusal to allow me that VAT credit, that VAT recovery, under 83(1)(c. And we saw Lord Justice Singh's decision in ARIA Technology that said what matters is not where you start, but where you end up between the taxpayer and the revenue.
Well, there may be 83(1)(c) cases, I would imagine, where there is a full appellate jurisdiction.
Quite so much.
Whether something is, for example, 0 rated as opposed to standard rated.
I agree.
So it's not which of the bits of Section 83 you come under. It's what is the decision that you're challenging.
Well, my lord, that may be where there's a point of disagreement. It is the nature of the jurisdiction of the tribunal that is driven by which gateway in Section 83 is engaged.
Well, Section 83(1)(c) may give rise to two different jurisdictions. One might be a full appellate jurisdiction. There is a disagreement about whether some food stuff is liable to VAT.
Yes.
Or it may give rise to a supervisory jurisdiction where the question is, have HMRC validly exercised their discretion under Regulation 29? You can't tell simply from looking at 83(1)(c) which of those approaches the FTT is going to apply.
But I think the point my lord is making is that the answer to the nature of the jurisdiction is driven by the statutory characterisation of the appeal. To put the point the other way around, there is no authority, certainly none that I can find, there is no authority that says you can have a supervisory jurisdiction on an appeal against an assessment. For reasons I've sought to establish, the tribunal cannot discharge its function of finding the correct amount of tax properly due. And that, my lord, I mean, I'm either right on that or I'm wrong, but that is a very high hurdle that I say needs to be overcome for an appeal against an assessment. Yeah, no, I understand.
You've made the submission very clearly.
I'm now very conscious of time, my lord. My lord, I think I should draw stumps on Proposition 3 at that point. Proposition 4, I will put very briefly, that properly understood, in any event, this appeal challenges HMRC's assessments on best judgment ground and therefore on quantum grounds, repeating that submission, itself thereby engaging the tribunal's appellate jurisdiction. You've been taken to the relevant documents. Grounds of appeal, my lord, there are 3 requirements of grounds of appeal. 1, to say why the assessment was wrong. 2, to enable HMRC to understand the case they need to make. 3, to enable HMRC to prepare the statement of case. There's no dispute as to what the relevant authorities say. There is a dispute about the result of their application. I would invite your lordships to bear in mind that the overriding objective in the First-tier Tribunal inbuilds into the DNA of the tribunal some degree of flexibility and informality. The point, my lord, is that understanding what grounds of appeal say and mean is an objective analysis, not what HMRC interprets them. Nowhere in those grounds of appeal is the word discretion used. Nowhere in those grounds of appeal does it use the words alternative evidence. Nowhere in the grounds of appeal does it say that does the appellant say that HMRC should accept documents as if they were valid VAT invoices. The thrust of the grounds of appeal is this. That is to vacate the assessment. That's the desired outcome of the appeal. That's at page 64. And the same is at paragraph 8 at page 66, to quash the decision. So in ordinary non-technical language, to treat the assessment as if it never had been made. On a section 83(1) appeal, that's only possible where there has not been an honest and genuine attempt. But if that does not succeed, and I really am repeating myself, it is the tribunal's function to find the correct amount of tax.
Yeah. It's very odd, though, that the grounds of appeal don't assert that you've got the invoices.
It's difficult to say much there, my lord. These grounds of appeal are probably some of the more forensically examined grounds of appeal that ever come before the courts or the tribunals.
There's a pretty obvious point to make. You've got the invoices and you had them all along. You say, well, we've got them.
So, my lord, what I say, and if I may draw your attention in the very limited time before the short adjournment, just to say this, I say that plainly what the grounds of appeal do is they take specific issue with the no evidence allegation, and that's at paragraph 7F.
Yeah.
The grounds assert that HMRC's core reason for making the assessment is factually wrong, and it says in terms evidence has been provided or made available. The grounds also assert that HMRC have acted unreasonably.
Yes.
A, explicitly in relation to the unreasonable amounts of records requested before the assessment was made, and B, implicitly in HMRC's rejection of the offer made to inspect the records. I say this, what then actually happened, I'll be very brief, my lord, and I say this respectfully to my own friend Mr. Watkinson and respectfully to those instructing him, is that where this might have started to go awry is when HMRC decided to reframe the grounds of appeal in their statement of case. And if I could please very quickly ask you to turn up the statement of case, that's in the supplementary bundle, tab 27, page 103. And if I could, I think it's the last tab in the bundle. If I could ask you please to, of course one is only making these points with the benefit of hindsight, much in the same way that the point is being taken against the appellant. At paragraph 1.5 on page 104, in my submission the reframing produces 3 errors. 1, it omits entirely the unreasonableness challenge in paragraph 7F. 2, it fails to mention that all of the business records requested, the reason for the assessment, were made available to HMRC. Mr. Brown showed you that document this morning. And 3, the grounds then proceed to presume the appeal was just a challenge to the exercise of discretion. And we say that's wrong, given the grounds properly understood, and given the nature of the tribunal's function upon an 83(1)P appeal.
Yeah.
My lord, you may well be pleased to hear that concludes proposition 4. May I pause very briefly and also turn my back?
Yes.
My lords, unless I can assist further, those are my submissions.
Thank you very much. All right, well, that seems like a convenient moment to break. How long do you think you're going to be, Mr. Watkinson?
Maybe an hour, my lord.
Well, in that case, I'll say 2:05.
All right.
Well done indeed.